Hello everyone, I'm Jerry Bilisadaga, a best criminology 4F student. In this video, I will be presenting on criminal procedure, especially roles 110 to 126. Role 110, prosecution of offenses. 1. Starting a case. Criminal cases are initiated by filing a complaint for an information. Number 2. Responsibility for prosecution. Public prosecutors handle cases, but private complainants may assist under certain conditions. 3. Requirements for complaint. Information. It must be in writing, sign, identify the accused, specify the offense, and detailed facts to establish probable cause. And number 4, jurisdiction. Cases must be filed in the court where the crime occurred unless stated otherwise by law. 5. Private crimes. Crimes like adultery require the offended party to file the case. For example, in theft, the prosecutor files an information based on a complaint. The prosecution of civil actions in relation to criminal matters is covered by Criminal Procedure Rule 111. Prosecution of civil actions. It permits crime victims to bring civil lawsuits for compensation or other remedies during or following a criminal trial. 1. Civil actions with criminal charges. During the course of a criminal proceeding, victims may attempt to obtain damages or other civil claims. Number 2. Impact of a criminal outcome. Although a civil action may still proceed even if the defendant is acquitted, in a criminal conviction may have an impact. Number 3. Civil actions are separate legal proceedings that may be postponed until the criminal case is resolved. Example, a person injured by a drunk driver can file a civil lawsuit for damages while the driver is prosecuted for DUI. If the driver is convicted, it may support the civil case, but the victim can still win the civil case even if the driver is acquitted. Rule 112 for Criminal Procedure Code initial investigation to ascertain if there is a probable cause to charge someone a crime. Rule 112 describes the steps involved in preliminary investigation. It makes sure that only cases with enough evidence go to trial, preventing unfair charges. The prosecutor looks into the complaint after it is filed by the complainant. The prosecutor examines the allegation, the accused and complainant's affidavits, and supporting document action. The defendant may submit a counter affidavit. The prosecutor brings charges in court if there is probable cause. If there is no probable cause, the case is dropped. Example, a person files a theft complaint against someone. The prosecutor reviews the evidence and the accused defense. If sufficient evidence is found, the case goes to court. If not, the case is dismissed. Rule 113. Criminal procedure. In the rules of court, synopsis, arrest is the process of putting someone into custody to make sure they show up for court or answer for a crime, and it is governed by Rule 113. The procedure for making an arrest, the circumstances in which it may take place, and rights of the arrested individual are all described. 1. Arrest definition. Section 1. Arrest refers to a legal process of placing someone under custody, making sure the individual is available to testify in court over a criminal charge is the goal. Procedure for arrest. Section 2. Unless the individual refuses or runs away, the officer must explain their authority and mission. If the arresting officer is aware of a warrant, they must produce it. But if do not, the arrest remains legitimate. 3. Without a warrant, make an arrest. Section 5. A warrantless arrest may be made in the following situations: convicted of committing, trying, or having recently committed a crime is known as being in flagrante delicto. When an officer suspects someone of committing a crime, this is known as a hot pursuit. A prisoner who breaks out of custody or incarceration is known as an escape. Rule 114. Bail. Bail is a security, cash, bond, or organizations allowing an accused temporarily freedom while ensuring court attendance. It is a constitutional right except for crimes punishable by reclusion perpetua or life imprisonment, or death if evidence of guilt is strong. 1. Types of bail: cash, surety bond, property bond, or recognizance. 2. Conditions appear in court, avoid offenses, and follow court orders. 3. Cancellation. Bail is revoked for non-appearance, violation of conditions, or case resolution. 4. Non-bailable offenses requires a hearing. Bail is denied if evidence of guilt is strong. Example: bailable offense, Ana posts 20,000 pesos for theft and is released but must attend hearings. Non-bailable offense, example is 1. Charged with murder is denied bail due to strong evidence of guilt. Rule 115. Accused rights throughout a criminal proceeding. The accused is entitled to several rights that guarantee due process and justice. 1. The presumption of innocence until a crime is proven. 2. The right to be aware of charges. Free right to counsel if you are impoverished. 4. Right to a fair trial that expedited. 5. Freedom from self-incrimination. 6. Witness cross-examination rights. 7. Right to challenge a decision. As a illustration, arrest. During her robbery arrest, Maria is advised of her legal rights. Trial. To maintain impartiality, Jose cross-examines witnesses. Appeal. Ana takes her conviction to higher court to challenge it. Rule 116. Arraignment and plea. Arraignment, the accused is brought before the court in form of the charges and asked to enter a plea. Plea, guilty, may lead to sentencing after ensuring it is voluntary. Not guilty, leads to trial. Purpose, ensures the accused understands the charges and their rights, protecting due process. Example, during arraignment, Maria is charged with theft. She pleads not guilty, so the court schedules a trial to present evidence. Rule 117, motion to quash. A motion to quash challenges the validity of a criminal complaint or information before entering a plea. It may be based on the legal defects or issues such as lack of jurisdictions, double jeopardy, or insufficient facts to constitute an offense. Purpose allows the accused to question the legality of the charge without proceeding to trial. Grounds common reasons include lack of jurisdiction over the offense or person, violation of the right against double jeopardy, the charge fails to state an offense, improper venue or prescription of the offense, effect. If granted, the case is dismissed. If denied, the accused must be enter a plea and the case proceeds to trial. Example, 1 files a motion to quash, arguing that the court has no jurisdiction because the alleged crime happened outside its territory. If the court agrees, the case is dismissed. Otherwise, it moves forward. Rule 118, pre-trial. Pre-trial is the procedural step to simplify issues, consider stipulations or facts, and explore possible settlements or plea bargains before trial. It ensures efficiency in the proceedings. Purpose, define and narrow the issues. Explore admissions, stipulations, or plea agreements. Resolve procedural matters like the admissibility of evidence. Procedure, both parties meet with the judge to discuss the case. Agreements made are documented and bind the parties during the trial. Example, during pre-trial, the prosecution and defense agree that the accused owns the car involved in the incident, avoiding unnecessary evidence presentation during trial. Rule 119, trial. The trial is the formal process with both parties present evidence, witnesses, and arguments before the court to determine the guilt or innocence of the accused. Explanation. Purpose: to give both the prosecution and defense a chance to present their case. The court evaluates the evidence to reach a verdict. 2. Procedure. Opening statements, both parties outline their case. Presentation of evidence, witnesses are called, and evidence is presented. Cross-examination. The opposing party may question the witnesses. Closing arguments, both sides summarize their case decision. The judge or jury delivers the verdict. Rule 120. Making a decision following a trial. The court renders a judgment deciding whether the defendant is guilty or innocent, and if found guilty, imposes a penalty. After considering all available information, the court issues a written ruling. If convicted, a penalty is imposed by the court. Example, with justifications provided in the written ruling, the court finds the accused guilty of stealing and sentences them to 5 years in prison. A new trial or reconsideration may sought if new evidence emerged or if there were major mistakes during the trial. New trial requested due to newly found evidence or errors in the trial process. A reconsideration, a review of the decision due to legal mistakes or new information. Example, after a guilty verdict, the defense uncovers new evidence and asks for a new trial to review the judgment. Rule 122. Appeal. An appeal enables either the accused or the prosecution to contest a trial court's decision in a higher court. Rule 123. Procedure in the municipal trial court. This rule outlines the steps in municipal trial court which handle less serious cases, from filing a complaint to the final judgment. Filing. A complaint is filed. Trial. Issues are simplified and settlements explored. Trial. Evidence and witnesses are presented. Judgment. The court issues a decision. Appeal. The decision can be appealed to the regional trial court. Example, in a theft case, the municipal court hears the evidence, finds the accused guilty, and sentences them. The accused can appeal to the regional trial court. Rule 124. Procedure in the court of trial. This rule describes the steps followed during trials in higher courts, like the regional trial court. For serious criminal offenses, pre-trial simplifies issues and explores possible settlements. Trial. Evidence is presented and witnesses are cross-examined. A judgment. The court issues a decision. Appeal. The judgment can be appealed to the higher court. Example, in a theft case, the regional trial court reviews the evidence, renders a verdict, and the convicted party may appeal the decision. Rule 125. Procedure in the Supreme Court. This rule outlines the process for cases in the Supreme Court, including appeals and petitions for review. Filing, a party files a petition to appeal a lower court decision. Review. The Supreme Court decides whether to accept the petition and may issue a TRO. Hearing. If accepted hearings are held and arguments are presented. Judgment. The court issues a final decision which must be executed. Example, a convicted person appeals to the Supreme Court. The court reviews the case and issues a final ruling. Rule 126. Search and seizure. This rule details the legal process for searches and seizures by law enforcement, ensuring they comply with constitutional right. Search warrant. A judge issues the warrant based on probable cause, specifying the location and items to search for. Search and seizure. Officers search the area and confiscate any illegal items found. Exceptions. Searches can occur without warrant in case like hot pursuit or with the person's consent. Example, police obtain search warrant, discover illegal drugs in the suspect's house, and seize them as evidence.